Good evening, everyone. This is day 3 of the Express Certificate course on patents being conducted by the DPIIT-IPR Chair, IIT ISM Dhanbad, as the part of a certificate course in IPR under the norms put forward by SPRIA. I have pleasure of welcoming Reema Sahni Mediratta Ma'am, Scientist D at the Innovation and Translation Research Unit, ICMR, Ministry of Health and Family Welfare, Government of India. She brings with her more than 15 years of experience in intellectual property and technology transfer. Ma'am has led the ITTO at IP Delhi, worked with the School of International Biodesign, and managed ICMR's IP portfolio. She holds a master's in life sciences, a diploma in IPR from NLU Bangalore, and is a registered patent and trademark agent, as well as an RTTP professional. She is also the recipient of the TST Women Scientists C Fellowship. Her pioneering work in IP management and technology transfer makes her a valuable resource for this course, and we are privileged to have her with us and share her vast experience.
Good evening to everyone, and thank you so much for having me here. So I request everyone to introduce, if possible, because then I will have an idea if they have prior knowledge about technology transfer or not.
Okay. Ma'am, we'll have to make slide settings. Just give me a moment because in the previous sessions, this speaker was being disrupted while, if some kind of technical glitch or something happened at other people's end. I'll just, enable mic settings for everybody so that they're able to have a conversation with you. Just give me a moment, ma'am.
Sure. And also, please confirm if my slides are visible to you or not.
Yes, ma'am, it's visible.
Thank you.
I would request all the participants to one by one introduce themselves. I would request participants to turn on your mics for a moment and briefly introduce themselves so that we can proceed with the session.
Anyways, we can start with our presentation. So you can give me brief about all our startups or students or from any company, industry.
So, ma'am, yeah, I think they're typing in the chat box. We can,
Okay.
those who are comfortable turning on their mics and speaking here, please make sure that you introduce yourself briefly so that we can proceed with the sessions.
Okay, now I have fair idea about the participants. So mostly they are LLM students. Okay. So thank you so much for having me here. So you all are aware about what are IPR, intellectual property rights, right? We are filing patent applications, trademark, copyright, and industrial design. What is the future of granted patents and registered trademarks, industrial designs, and copyright? The answer is technology transfer. Because earlier the era was like whenever any scientist, scholar is ready with their innovation, they were always inclined towards publication of their work. But nowadays, our government also is emphasizing on filing or protecting their IP. So not just about filing and grant of your IP, they are also now motivating you for the transfer of your technology. So technology transfer, it is basically the process of sharing, disseminating, or moving technology, knowledge, skills, processes, or innovations from one organization, person, or country to another. The main aim behind that is to enable others to use or further develop that technology for commercial, social, or research purpose. So technology can be transferred from university to industry, from government to private sector, from company to company, international technology transfer. So in simple words, if I have to define technology transfer, it is basically transfer of technology from innovator to any industry, startup, or SMEs. So it seems very simple process, but it is very tedious because a multifaceted process and multiple stakeholders are involved. With the multiple stakeholders with a single aim for the benefit of our society. Because everyone has single aim that their technology or the final product should be in the hand of end users. Now the question arises, what gets transferred? Any data can be transferred. Technology, product, process, prototype, it can be transferred. Any accessories, algorithm, software, you can also transfer that. And any material, for example, in one university, one student is working on some sequencing, and at IIT, you are sitting at Dhanbad, IIT Dhanbad, and you need that material for which supports your research work. To avoid the reinventing of a wheel, you can always approach that scholar for that material, and it can be done by technology transfer, under material transfer category. And know how the skill set can also be transferred, and associated IP, like for the technology, if you have filed a patent application or trademark application or industrial design, you can transfer that as well. So these are the stakeholders, as I mentioned earlier, that in technology transfer process, there is involvement of multiple stakeholders. On the left hand side, you can see technology developer, the innovator or that university, that startup who is already working on that technology are called technology developer. And on the right side, there is technology seeker or buyer who may hold interest in your technology. And there is one connector, technology supporters, who help to facilitate technology transfer. These are technology transfer offices or any IP cell at your organization. So they are helping you to facilitate technology transfer from tech developer to tech buyer. And at the end, the happy faces are the end user of your technology. Now, what is the role of facilitators, technology transfer offices, and IP cell? So they play critical role for innovation management at any academic institution or incubator. And at IIT Dhanbad as well, there is one dedicated IP and tech transfer cell. So basically, they help you to formulate IP and technology transfer strategy, which is very specific for your technology. They help you in facilitating technology transfer. They also help you in business facilitation, because for a researcher, it is very tough to, approach industry. So you need people with techno-legal mindset. And at any IP and tech transfer cell, they have all the staff has that kind of skill set. And forging linkages and doing capacity building for all the innovators. So they play a crucial role when it comes to commercialization or technology transfer. So what is the significance of technology transfer? First of all, it fosters the culture of innovation and creativity at your organization and helps to build a brand value for your organization, for your startup, and for the innovator as well. Because the innovative product and processes which you are working upon, once they will be commercialized, it will be very helpful for our society, for uplifting their lifestyle. It may be in any domain. And also it is a source of revenue for any academic institution, because as per the IP policy of most of the academic institution, whenever you transfer any technology, then the buyer has to give revenue in form of upfront payment, milestone payment, royalty amount, or sum of all this. So this manner, your academic institution is earning revenue out of your technology, and this can be further utilized for strengthening the R&D ecosystem at your organization. And also there is a scope for distribution of revenue amongst innovators. The next is it helps to create jobs. For example, if you are having your own startup, then you need people with different expertise. So having startup is like running a business. So indirectly or directly, you are creating jobs for others as well. And of course, the products which you are working upon, it helps to improve the quality of life of our society. The next is technology transfer model in any academic institution. How it goes from development to commercialization stage. The first step, this implies to any IP filing as well. So first, innovator has to disclose about their technology. And one thing you should remember, this is after filing your IP. And it is very important to evaluate your technology to see what are the strengths and weakness in your technology. Because if you will be aware about your strength and weakness in the technology, then you will be able to convince the industry. And then you have to market. You have to do the marketing about your technology. This is similar to if Apple is launching their new series. There will be something in the public domain. There will be news in newspaper or social media or anywhere you can name. So this is the way people will be aware about their product. And likewise, if you are working on any technology, then your TTO will publish about your technology so that the industry may know about your technology. If any industry may hold interest in your technology, they will approach and get back to the TTO. And then next step is negotiation. So this involves the financials as well. And if both the parties are on same page, then the licensing of the technology happens. So these are the tech transfer steps. First, the technology transfer officer will understand about your technology, what is the USP of your technology, and they will identify the key strength in your technology by tech assessment. And in tech assessment, they will see what is the technical edge of your technology as compared to the already existing technology, what is the market need of your technology, and what is TRL status of the technology. And accordingly, they formulate the strategy for tech transfer. And then is route type marketing, how they will market your technology. And the last is negotiation and deal closure. So technology transfer, it is like first you will check or assess the technology, like how technically strong is that technology? What is the IP strength? If the innovator has already filed IP, then what are the chances of grant of or registration of that IP? And if anyone has already filed IP before you have filed, then what are the chances? The third is market need. If there is need of your technology in the market, if yes, then any industry will show interest in your technology, otherwise no. The last is maturity stage. If your technology, it is very important to include TRL in the technology assessment report, because industries may evaluate the strength on the basis of maturity stage as well. Because if the technology is at early stage, or then the risk associated with the technology are very high if it will work on pilot scale or not. Whereas the mature technology involves low risk. So from the tech assessment, the tech transfer professional will get to know the unique feature and usefulness of the technology, stage of development or maturity stage of the invention, advantages of the technology over the existing technology, how your technology is better than already existing technologies, and areas of application. So it is very important. For example, uh, during COVID era, there was, test for diagnosis. Earlier, it used to take 1 week or more than 1 week. And later on, someone invented fast track kits. And within fraction of second, we used to get the, result. So in that case, the later technology has technical edge over the already existing technology, because it is better than already existing technology. It is reducing the time, and also it is cost effective too. Now, how we can do the technology transfer? So there are different ways like licensing, assignment, and joint venture. In case of licensing, you transfer the technology from innovator to industry, whereas you're not transferring your entire rights. It is just like you are giving your house on rent. Whereas in case of assignment, you transfer entire your IP rights to the industry. And after transfer of that, after that assignment, you will not hold any right on your technology. So in case of academia, we always recommend, always put one clause in license agreement that all the future rights of research will remain with the academic institution itself. The third type is joint venture. When academia and industry, they join hand together and work towards development of technology till its commercialization. And to support all types of technology transfer, the the licensing, assignment, and joint venture agreement should be, it should be very crystal clear. All the clauses should be added in those agreements so that in future there may be no any further issue. Now, it depends upon technology to technology and on innovator to different type of routes for commercialization can be opted for. Someone wants to transfer know-how of the technology wherein no IP is associated, they can transfer. So it is myth that only any technology wherein IP has been filed, IPR has been filed, can be transferred. No, we can transfer the skill set of the technology as well. The second is you can transfer the single IP as well as the entire portfolio too. And you can do opt for technology assignment too. It depends upon innovator as well. Suppose if they are thinking in future they don't want to do any work in technology and they are getting a good deal from the industry as well, then they can transfer entire rights to the industry. The next is startup and spin-off formation. So spin-off is the technical term which we use for any academic startup which is formed by any faculty or innovator. So you can form that and you can take the technology from your academic institution and work towards development of that technology. So for startups, it is there are many subsidies which are given to the startups. And also there are different government and non-government organizations which are providing funding to these startups. The next is you can go for joint venture as well. Tools for technologies transfer. The most important tool is policy framework, which is very important. The next is license agreement, assignment, non-disclosure agreement, and material transfer agreement. The next is marketing content, which is tech brief, brochure, and advertisement. So first is policy framework. So I think most of the academic institutions are having their IP and tech transfer policy. So this policy acts as a guiding document for any institution and startup regarding IP protection and commercialization. So within the IP policy, there is a set of procedure for identification, evaluation, protection, and management of IP. So it deals with the ownership and commercialization framework as well. And it is applicable to all the professional academic employees, whether full-time or part-time, and for students as well. And in case of startup, it is implemented for all the stakeholders. In case of absence of any policy framework, we may face the issue like IP ownership and issue regarding revenue share. Because in case of IP policy, IP ownership is well defined. And in most of the cases, IP is owned by institution itself because all the resources for doing research works are provided by institution itself. The next is issue regarding revenue sharing. In IP policy itself, there is revenue sharing model wherein who will own, uh, how much share is well defined. And mostly the some share is given to the R&D cell, some to the IP cell, and rest of the funds are distributed amongst all the innovators. And nowadays, all the academic institutions are following that pattern wherein inventors get most of the benefits out of this. So these agreement, non-disclosure agreement, whenever you are thinking of discussion with any industry, then it is always advisable to sign non-disclosure agreement so that in future, if they are trying to copy your work, you may take action against that person. And this agreement will act as evidence for you. License agreement whenever you are transferring the technology, assignment when you are transferring complete rights over the technology. So these agreements, they act as backbone for you. So next is marketing content. Marketing content is very, very useful because it is just like you are telling, ecosystem that you are working on this technology. So tech brief is basically the one pager wherein you describe about the technology, what is technology about, what is the USP of that technology, and what are the benefits of this technology, what is the IP status of the technology. And the most important thing is that in the marketing content, you should never ever disclose about the confidential information about your technology. Because if the confidential information will be disclosed, then no industry will pay you for taking your technology. They may say, okay, this technology is already in the public domain. We can copy it from the that publication, and there's no need to pay that. That's why whenever we do the technology transfer, so in case of exclusive licensing, we give the technology to only one industry. Where in non-exclusive licensing, we can give it to more than two industry. So it becomes very important to mention about the confidentiality terms in the agreement itself. Why? Because suppose if one industry to whom you have transferred the technology has published about the confidential information about the technology, then the other industry may oppose that or may have resistance for that, because they will say, if it is in the public domain, then I will not pay you royalty. Anyone can copy them. Again, the next is brochure. Brochure is also the detailed information about the technology. And advertisement, you can advertise about your technology on newspaper and any social media. But again, the principle is same. You are not supposed to disclose the confidential information. Now they you can use marketing strategy. You can use one of them, or you can use all kind of marketing strategies depending upon your technology. First, you can have one-to-one discussion with the industry. The second is you can use the social media like LinkedIn, Instagram, Twitter, because now I have seen most of the organization have their profile in all the social media. So you can approach industry through these handles as well. The third is exhibition. You can participate in exhibition. You can talk to the industry there. Again, don't disclose about the confidential information. And the next is publication. You can publish in the newspaper, but don't try to disclose the confidential information. So these are the strategies you can use for approaching the industry. So the most important thing is the next is action at various stages of technology transfer. The first is so these are the any research scholar, I think they must be following these good practices as well, because I always recommend to innovator that first set the milestone for your research work. Whatever you are doing, start writing on your notebook, so that in future, if you are not forget about that, okay, this was the protocol, and this is the way I further worked upon the technology. Then that your diary or any Word document on your system, it will act as evidence. So maintain a logbook and scout for IP in your research at early stage. Suppose you are working on the technology. So this is a good practice whenever you are choosing any research topic for your PhD as well. The first you just go through that Google pattern and mention about your topic and check who all have filed patent application, or if there are any granted patent on similar kind of you know field. So this way you can search and improvise your project, your research work. The next is always connect with IP and tech transfer office, because they will help you, because what they do, for example, whenever you are ready with your technology, you will contact them for IP protection. At that stage as well, if you are filing patent application, they will conduct a thorough, evaluation. They will conduct due diligence and check your technology on the basis of its novelty, industrial strength, and its commercialization potential, right? And also they will check if it is as per the Indian Patent Act 1970 or no. And then they will, after the proper due diligence, if they found there is something similar to your technology, they will advise you how you can fill those gaps and improvise your technology so that it can become patentable. And after that, at first step, it is like they will help you in improvisation of your technology. And once you have filed patent application, they will ask you for, they will advise you for filing associated IP like industrial design, copyright, or this thing, um, trademark. This is why this is like in future, if you are going to transfer your technology or you need funds, or then all the investors or industry may ask you about the IP portfolio. And this IP portfolio is very helpful in commercialization of your technology. Then the industry thinks, okay, they have a strong IP portfolio, and it is very beneficial that they can transfer the technology. And next is validate involved factor and risk at each stage of translation. For example, if your technology is from healthcare sector, it is medical devices, then at the first stage you can check if you can what are the regulatory compliances which you can you know which is implemented for your technology. You can search for that, and you can check for ISO certification, which is mandatory for your technology. And likewise, if your technology is from food industry, then also FSSAI certification. So for different kind of technology, there are different kind of certification. So you always start scouting for these compliances at the early stages, so that whenever you are transferring or commercializing your technology, there will be no any regulatory rejection. And also, if you are working on any technology, in parallel to that, you should always look for the similar development and study for advancement of your technology, because now a very fast track era, every day you will there is improvised version of earlier technology. So these factors will help you in, filling the gap and evolving your technology as well. So that whenever you are launching your technology in market, it will not be an obsolete technology. So always look for similar studies, similar development, so that it can help you in improvising your technology. The next is very important, which is networking with the relevant industry partner. So you can always check for the industry who may hold interest in your technology. You can discuss about their pain point. And trust me, if you will work, around their pain point, then the chances of transfer of your technology will be increased. So because in Copenhagen, there is a good practice. What they are doing, whenever they will get idea, which is invention disclosure form from any innovator, first they map it with the industry. They will have meeting with the industry that if this researcher will work on this technology, will you hold interest in its technology? When they say yes, then they start working on it, so that in future they will take or opt that technology. In case of academic institution, they also have a few projects wherein industry approach faculty member or researcher. They give their problem statement to them and request them to work around that. They provide all the funding. And then the faculty member or researcher work around those problem statement. And the benefit is this is win-win situation for the academic institution as well as for the industry as well, because the work which will be generated by that academic institution, it will be adopted by industry. But in all these processes, the most important thing or the most important role will be played by TTO and the techno-legal agreements like licensing agreement, assignment agreement, or collaboration agreement. So these should be curated or drafted with utmost care. And all the clauses should be included in. Like in our case, we used to put, you know, financials as well, but will be upfront payment if or milestone payment or revenue or royalty, and everything is added in that. And most important, the confidentiality. So it is very important that your agreement should be very, very strong so that in future you may not face any issue because of that technology transfer. And that's why I have mentioned the tools or framework at any organization. That's why IP and TT policy plays very important role for any technology transfer or commercialization at any academic institution, because it has all the rules and regulations. So innovator can go through that IP and TT policy and they will know about their rights or academic institution rights and R&D cell or IP and TT cell. And this is actually the guiding document which is created for all the stakeholders at academic institution. And it is very, very helpful. So we always recommend to academic institution and to the startups as well to have your IP and tech transfer policy. The next is myths which are associated with any technology transfer process. Like the first is any technology can be transferred. No, this is wrong. Only the technology which has worked can be transferred. If there is no need of that technology, then it can't be transferred. It should have the market need first. Suppose now, when there was COVID era, there was a demand of mask and diagnostic kit. And after that, there was no any demand and no any innovator is working on the same kind of technology because the industry will not buy that. If there will be demand, then there will be transfer and then there will be commercialization. The second is IP protection is must. No, because we can transfer the know-how of the technology as well. Because in some cases we have seen, industry, few innovators are not interested to protect the IP. They think they want to protect it as a trade secret and in future they will transfer it. But my recommendation as a tech transfer professional is always file or protect your IP so that you will not face any issue in the future. That's why it is always said that copyright, it is an auto-generated right. But we still ask innovator to file copyright application because if in future your rights will be infringed by someone, then you can take legal action. The next is anyone can transfer the technology. This is also wrong. Only the person who hold the ownership, like in case of academic institution, their the rights is always with the academic institution. And innovators and the researcher, they are added always as innovator or inventor. So the authorized person from the academic institution will be able to sign the license agreement. So this is basically all about the technology transfer process in brief. So basically why it matters, because it accelerates innovation, it reduces duplication of research, promote economic development, enhances collaboration with academia, industry, and government, and enables commercialization of the research work. So this is all from my side. I guess we can take the question right now. If anyone has any query, you may please discuss with me. I'm happy to take your queries.
Thank you, ma'am, for the insightful discussion on technology transfer, covering its significance, types, ways, rules, tools, etc. The floor is now open for questions. Please feel free to ask any questions you have.
Thank you so much, ma'am, for your question. So, actually, if there is any sample technology transfer document which could show licensor and licensee and what are the royalties, what is the best way, like you are explaining about upfront royalties and that, like what is the best way that we can mention, then it would be clear to us. Hello.
Hello, sorry, there was some issue. Can you please explain your question again?
Like if you could explain with technology transfer, any sample technology transfer agreement, where what is the best method, like if some technology transfer is happening between the academic institution and for
Your
example,
voice
like
is
industry.
not clear. Your Ashokji, your voice is breaking and it is not clear to me. It is very, very slow.
Oh,
Can
is
any?
that fine? Now,
Yeah,
can you hear me?
little bit. Yes, yes.
Yeah, yeah. Thank you so much for your wonderful session. So my question is here, like if you could show us like how the technology, any sample agreement between the two parties, like licensor and licensee, and what is the best way that what kind of royalties? I mean, there are so many methods you explained, right? Like
Yes, yes.
upfront method or something. Which one is the best? Uh, and what based on what kind of technology, like which approach is the best one? So that is what
So
my question.
yes, yes, yes. So thank you for your question. Now it was audible as well. So there is no any set method or any uh, one type of strategy which we can use for that technology. So for each technology, depending upon the type of technology, we used to have different kind of technology transfer agreement, right? So in every see at academic institution, in most of the cases, we have done licensing agreement, like the simple agreement which we are transferring. There are very less number of joint venture, which is collaboration with the industry, and both work towards development of the technology. And also there are few cases, very, very few cases in which assignment happen, wherein the innovator or faculty has their own startup and they ask for all the rights in very few cases. So it depends upon academia to academia which kind of method they want to follow, and it should be covered in their IP policy as well. For example, when I was working with the DBT's flagship program, which is SAFE, in that case, there was licensing agreement, and also there was one option in case startup wishes to take the assignment, means all the rights from DBT, because the ownership was with DBT. So it was the case. And for any good technology transfer agreement, I would say all the clauses, like all the definition which we usually have in any agreement, like technology, how what are their definitions, grant of rights, what is the scope, are you willing to give license, or is it exclusive, non-exclusive, or is it assignment or collaboration? Then the payment terms. In few cases, we used to take upfront payment, in case royalty, in few milestone payment, or combination of all. Then the IP rights, in which who will own the IP. Then confidential information, as I discussed during my session as well, that we need to protect the confidential information. And then technical assistant and training clause, like if you are transferring the technology, then only the innovator is the one who is aware about that technology, right? When they are transferring it to any other industry, then they need hand holding for some time. So we always keep one clause like training and everything, and for limited period. Okay, and after that it is again the financials are involved, and also the limitation liabilities, indemnification clause, term and termination, dispute resolution. This is like in every, because most of the students are from law, which I'm presuming. So these are the standard clauses which we used to have in any agreement. So apart from that, these are the particular, you know, clauses which we put in licensing agreement, like ownership, then this financial royalty, sorry, what kind of payment you want, what kind of licensing you want to do. So these are the particular or specific which we add in the license agreement. Hope I answered your question, Ashokji.
I just thank you for your answer. And actually, I would like to discuss, like, recently we have one material transfer agreement where it is between the two different jurisdictions. So,
Okay.
as you said, in the coming to the dispute resolution. So, if it is from two different jurisdictions, normally they are putting a neutral jurisdiction like Singapore or some Switzerland or something. So most of the cases, like institutions doesn't have, I mean, say to invest. I mean, to go to Singapore and fight. In that cases, what are the?
Yes,
How
yes,
can we
yes.
write that?
Yes. So, for example, if I am sitting at Delhi and one industry is in Bombay, then for the arbitration, I will always prefer to keep my jurisdiction. That will be Delhi itself.
Okay.
So, because you are the technology developer, then it should be in your favor. So, this is
If it
the
is the
way.
international one, if it is the
International also, because that's why whenever I always advise if it is international collaboration, because in other countries, there are very hidden clauses as well. Ashok, I'll take this separately with you. I will discuss with you few cases as well. Right now, I can only suggest that it should be in your favor. You are technology developer, and yes, should be in your favor. Jurisdiction should be your place.
Yeah.
Otherwise, the
Okay.
cost for those cases in other countries will be very, very high.
Yeah, like because recently it happened. But anyway, we will take the discussion offline. And one more thing, like we have one more recent case, something like we had a agreement. We had agreement between the two parties, like one of the party. I mean, from IISM, we have they have the patent, and we successfully have the agreement between the two parties. And there we have written upfront payment. So we got the upfront payment also. But after we have kept the clause that it is after 3 years based on the sales of the product. So royalties will be uh, coming. Like those are the terms and conditions we have kept. Most of the cases we have seen that that is not getting materialized after 3 years. These are the challenges like we are facing. Though we got the upfront payment, but we are not getting the because that is not materialized. I mean the company, whatever the technology transfer we have done, so they have to come up with the product and they have to uh, commercialize, and out of that we get the royalties. So actually it is getting delayed even after 3 years also. So what can we do in these cases? Because we don't have much say, like because we already got the upfront payment, but after 3 years also, other than waiting for them to come up with, we don't have any other
Commercialization.
options.
See,
Yeah, yeah,
have
yeah.
you put a milestone payment option there?
No.
Okay. So means they are not able to commercialize that product, that technology.
Yeah, yeah, yeah. not able to commercialize, no, they have to come up with the product first of all.
Yes,
Scale
they
up.
are not. See, then there is a few option clause for termination as well. Like you have given some time. Within that time period, they have to, complete that development
Yeah, in
of
that case, we
product.
may lose time
Yes,
and as
this
well.
is the
Yeah.
catch here. This is the catch here. It is very important to put that clause. Okay. So milestones are like you are giving them deadline. Okay, within this period you have to do this, and within this period, otherwise we will terminate your agreement and we will give it to any other, uh, this one, what you say, any other company or any industry. You can say that.
Oh, okay.
Yes.
Okay, thank you.
Yeah, thank you. Hope I answered you.
Do we have any more questions? Participants, please go ahead if you have any more question. Okay, so for the session feedback, you have a form in the Google, in the chat box. I'm going to attach it over there. You might find it from there. Please make sure that before you leave the meeting, you fill in this form. This is essential to get your certificates and also to mark your attendance. As we conclude the 3-day session, I'd like to extend my heartfelt gratitude to our esteemed speaker for sharing valuable insights and expertise. Thank you to all the participants for your active engagement and contributions, making this a truly enriching experience. Thank you, ma'am.
Thank you so much. Thank you. Okay.
Ma'am, if you want, you can leave the meeting. Participants are required to fill in a form and they will
Sure.
also.
Thank you. Thank you. Thank you.
Thanks a lot, ma'am.